Welcome to the Law in Motion calendar in Department 501, which is the real property court in San Francisco Superior Court. We hold this calendar every single day at 9:30 a.m. except for court holidays. If you provide notice to the other side that you are going to be presenting a request to the judge in a form of the motion at 9:30 a.m. on a Law in Motion calendar, you as the moving party must file and serve your moving papers in advance of the hearing. You must make sure that you provide sufficient notice. Every motion requires a different notice. Generally, it is 16 court days. However, there are some motions that only require 5 calendar days. You will need to know how much notice you need to provide. Also account for the method of service. If you serve personally, then there is no additional time required. If you serve by mail, then there is a 5 additional day waiting period. If you serve electronically or by overnight mail, that adds on 2 court days to your notice requirement. Please make sure you know what notice requirements are for your particular motion before you file it. Otherwise, you just may waste your time and not get your hearing on the date that you want. Make sure you count the days correctly and make sure to consult the court holiday calendar for the court days. This court has additional holidays that you may not be aware of. The calendar is available on the court's website. As an opposing party, you have a right to file a written opposition. For most motions, there is a deadline to file the written opposition. For some motions, you are not required to file a written opposition and you may oppose orally. Please make sure you know what those motions are. The best way to find that out is to ask for assistance from Access Center or from the Eviction Defense Collaborative. They will give you instructions on procedure. Unfortunately, most of the times, the court is not allowed to give you legal advice. So you may not get that information directly from the court. Get advice from the Eviction Defense Collaborative or Access Center. Thereafter, the moving party has a right to file a reply. After all the papers are filed, the judge will read all your papers, the moving papers, the opposition, and the reply. 1 business day before your noticed hearing, the judge will issue their tentative ruling. The tentative ruling will give you an indication as to which way the judge is leaning. The judge may decide to grant the motion, the judge may decide to deny the motion, the judge may decide to partially grant and partially deny the motion, or if the judge does not have enough information in your papers, the judge may ask for a hearing. If the tentative ruling issued by the judge is grant or deny, and you are not in agreement with the judge's decision, you must let the other side know between 3 p.m. and 4 p.m. the day before the hearing that you are planning on appearing in court the next day at 9:30 a.m. to convince the judge to change their mind. That is called contesting the tentative ruling. You must give notice to the other side. Otherwise, the judge will not be able to hear from you. If the tentative ruling is hearing required, it means the judge wants you present. The judge wants to ask you questions and the judge wants to get some clarifications before they make a decision. If the tentative ruling is hearing required, you do not need to let the other side know that you will be appearing. That is already requested by the court. At the conclusion of the hearing, the judge will make a ruling. Then the parties are responsible for preparing an order. Usually it is the prevailing party. However, if the prevailing party does not prepare an order for the judge to execute, then the party who did not prevail may take it upon themselves to prepare an order to move the case along. At that time, when the judge receives the order and it is in conformity with his ruling, and you may make sure that it is or is not in conformity with his ruling by looking at the court's minutes that are available on the court's website, the judge will then execute the order. That order will then have to be served by the party who prepared the order on the parties to the case who did not prepare the order. That is the judge's decision, and then the issue is resolved. The law in motion calendar is designed to resolve the discrete issues that arise along the way in your litigation before you get to trial, or before you get to a resolution otherwise. That is one issue at a time. You are not presenting your entire case to the judge for a resolution. For that, we will meet at the trial segment of this video.